So for the agenda today, we'll be starting with an introduction to our HIV in the Law project, and then going into the relevant legislation and how it applies to people living with HIV in healthcare settings when accessing tattooing, piercing and cosmetics as well. And then we'll have a group activity where you'll discuss some case studies. You should have received them in an email this morning, but we'll also share a link when it comes to it so that we can all access them together. We'll be doing it in breakout rooms, and we'll just apply kind of the learnings about the legislation that we've just spoken about to some case studies examples. We'll then come back and feedback, and then I'll present again on how we can challenge unlawful treatment and behaviour in healthcare tattooing, piercing and cosmetics. And then, yeah, like I said, at 10:30, Adam will be joining for a Q&A session, and we're scheduled to finish at 11. But can I just check if anyone's having any issues before we begin? I can't see any hands or anything, so I'm going to presume that everything's okay, which is great. So I mentioned that this training is part of the HIV in the Law project, and I've included on this slide our theory of change to give you a better sense of what this project seeks to achieve. Some of you might have attended the training that my colleague Rosie led in June 2020, which was a longer session, kind of a whole afternoon session about HIV and discrimination in all settings. So if you did come to that, you'll already be aware of this project. But the overarching goal is that people living with HIV should face less discrimination from employers and services. And we think this can be achieved by enabling staff from HIV support services, such as yourselves, to inform people living with HIV of their rights and provide them with effective advocacy. And it's also crucial that employers and public and private service providers are aware of their legal obligations towards people living with HIV. And we're implementing 3 types of activity to reach these outcomes. And these are training, information, resources, and a service where we can give you advice and support when you are helping a client challenge unlawful discrimination. So we work with 2 solicitors, one of whom is Adam, to give us legal advice which informs the support we give as part of this project. And it also requires staff from HIV organisations such as yourselves to get in touch with us. So I have worked with a number of you on discrimination cases in the last year, and I'm really grateful for you all attending this training and continuing to engage with us on this project. So while I don't think many of you need convincing, I'm going to talk a little bit about why this training should be relevant to you. Everyone is entitled to certain protections under the law, and therefore the law can be useful in holding employers, public and private services, and the government to account. But it's not just about going to court, and there are many ways that you can use the law to promote the rights of your clients, and hopefully that's what we're going to address in this session. So we all know that HIV stigma and discrimination are unfortunately a continuing reality, and having a session specifically on discrimination in tattooing, cosmetics, piercing and healthcare is informed by the fact that we receive a significant number of cases related to discrimination in these settings through the Discrimination Advice Service from all over the country. And in tattooing, cosmetics and piercing, the common instance of discrimination involve being refused a service on the basis of your HIV status, even asking about someone's HIV status before a procedure or the provision of a service, and being told that providing that service requires kind of extra cleaning or extra sterilisation steps. But in fact, it's illegal to refuse to provide these services to someone on the basis of their HIV status. And this is because universal precautions are entirely, well, it's because it's a breach of the Equality Act, but the kind of reasoning behind why it's unnecessary and is because universal precautions are entirely sufficient to protect clients and staff. It's unnecessary and illegal to collect information about HIV status in the context of tattooing, piercing and cosmetic or routine beauty treatments. And universal precautions are essential in these settings because, as we know, 1 in 16 people in the UK are unaware that they're living with HIV. So any infection control procedure which relies on a diagnosis is completely ineffective. And this is, of course, not to mention that U equals U, and that people who are diagnosed are very likely to be on effective treatment and less likely to pass it on in these settings. So in terms of healthcare, the General Medical Council and the Nursing and Midwifery Council guidance requires all doctors to treat people, it requires all doctors and nurses and midwives to treat people fairly and without discrimination, and to challenge colleagues if they do not follow this guidance. And GMC guidance specifically states that treatment must not be denied to a patient because their medical condition puts you at risk. As before, universal precautions exist in these settings, and everyone is treated as though they might have a bloodborne virus, and there should not be variation in treatment, which means that people living with HIV are treated differently or worse. However, data from Positive Voices demonstrate that the discrimination still occurs regularly in healthcare settings. 1 in 12 respondents felt they had been treated differently to other patients, and 1 in 20 felt that they had been refused healthcare or had a treatment or medical procedure delayed. And examples of discrimination which we have been made aware of include being moved to the end of the theatre operating lists, sometimes repeatedly, resulting in significant delays to treatment. But other examples include healthcare staff wearing additional protective equipment or deep cleaning beds when they wouldn't for other patients who don't have an HIV diagnosis. And breaches of confidentiality were also reported in healthcare settings, with someone's HIV status being shared without their consent. So yeah, moving on to the key legislation relevant to people living with HIV. These are the Equality Act 2010, the Data Protection Act 2018, which is GDPR in UK law, and the Human Rights Act of 1998. And I appreciate that everyone here might have varying levels of understanding and knowledge about these laws and how they apply in the settings that we're focusing on today. So we're just going to go through each piece of legislation so that we all have like a shared understanding before we consider how to use them to tackle discrimination. So beginning with the Equality Act, this law is the main form of legal protection against discrimination for people living with HIV. And it's the law that I use the most in my day-to-day work. And I'm sure that that will be the case for some of you as well. The Equality Act covers most aspects of life under 3 key areas. And this is employment, goods, facilities and services, which includes customer services, rented and private property, utilities, financial services, transport and leisure, and public services, which includes health, social care, benefits, public housing services, police and courts. And there are 9 protected characteristics in the Equality Act. And discrimination which happens because of one or more of these characteristics is unlawful under the Act. And we all have some of these characteristics. For example, sex or age. So the Act protects everyone from discrimination. And although people living with HIV might not personally identify as disabled, they are afforded protection under the Equality Act because HIV is legally classed as a disability from the point of diagnosis. The Act prohibits a range of discriminatory behaviours, and there's often overlap between different types of discrimination. So one situation can involve multiple types of discrimination. And I'm going to go through each form of discrimination now, and where possible, I've tried to include examples of how they apply in healthcare, cosmetics, piercings, and tattooing, just so we can centre our understanding of this in the context that we're focusing on. So the first type of discrimination is direct discrimination. And direct discrimination involves treating a person differently and worse because of a protected characteristic. So an example of direct discrimination could be that your client is refused a tattoo and the tattooer said he doesn't tattoo people with AIDS. An example in a healthcare setting is your client not receiving the same quality of care whilst in hospital as those without an HIV diagnosis because hospital staff say they don't want to treat them. In order for direct discrimination to apply, the person discriminating needs to know that your client is living with HIV. And if the direct discrimination isn't obvious, you may need to compare the unfair treatment to the treatment of someone without a disability or with a different disability to prove that they have been discriminated against. And this is called a comparator. So in the example of the kind of healthcare settings, it might not be immediately obvious that someone is is being treated differently or worse by healthcare staff until you compare it with the treatment received by someone without a diagnosis. So the next form of discrimination is associative discrimination, which is where someone is treated differently and worse because of someone they're with or someone they know with a protected characteristic. And this could be a parent, carer, child, partner, or friend. So an example could be your client's partner is living with HIV, but your client is refused a piercing on this basis. So again, for associative discrimination to take place, the person discriminating must know or suspect that the associate is living with HIV. Perceptive discrimination is where someone is treated differently and worse because they are assumed to have a protected characteristic. So, for example, a healthcare assistant wears additional protective equipment when treating a Black patient from South Africa on a ward because they're assumed to have HIV. And this type of discrimination is probably less relevant to our work because we mostly work with people who are actually living with HIV. However, it's worth noting that in the example provided, this behaviour could amount to racial discrimination as well as perceptive disability discrimination. Harassment is unwanted behaviour which a person with a protected characteristic finds offensive or which makes them feel intimidated or humiliated. An example could be an individual has booked an appointment for a tattoo, and when he arrives, he's asked about his HIV status on the consent form. He states that he's living with HIV, and the tattoo artist shrugs it off and says it's not a problem. However, while he's having the tattoo, the artist starts to make jokes about his HIV status, which make him feel intimidated. Victimisation is where a person is treated differently or worse because they have made or supported a claim about discrimination, or they are thought to be doing so. So, for example, a person living with HIV makes a complaint about disability discrimination by the police, but when they report a separate crime, the police refuse to investigate it. Unlike the forms of discrimination I've discussed so far, the next two types of discrimination can sometimes be lawful if they can be justified, but I'll go into more detail about what that means in a moment. So indirect discrimination is when a rule, policy, or practice applies to a wider group of people generally, but it has the effect of disadvantaging people with a particular protected characteristic, and it cannot be justified, i.e., which means it can't be shown to be intended to meet a legitimate objective in a fair, balanced, and reasonable way. I haven't come across much indirect discrimination outside of employment. So I'll give an example in that setting that kind of demonstrates it quite clearly. Your client's workplace has a promotion policy which requires staff to spend extended periods of time working abroad in order to qualify for an executive role. And someone living with HIV may be willing and able to do this work, but due to HIV-related immigration restrictions in certain countries, they may not be allowed to enter or stay for the kind of required amount of time or obtain a work visa. So for their employer to deny a promotion on these grounds alone, it would be indirect discrimination unless they can clearly justify why the policy was essential for the role or their business. But a policy which can be justified, for example, would be a taxi company which requires drivers not to be visually impaired. An important thing to remember is that in complaints of indirect discrimination, it doesn't matter if the organisation knows the complainant is living with HIV or not. The second type of discrimination that can be justified is discrimination arising from disability. So discrimination arising from disability is when you're treated unfairly because of something connected to your disability rather than the disability itself, and it cannot be justified. So unlike direct discrimination, there's no need to compare your situation with that of someone else. All you need is to show that you were treated unfavorably because of something connected to your disability. So to prove discrimination arising from disability, the person discriminating needs to know or could reasonably be expected to know that your client is living with HIV. So an example could be a private clinic turns down your client for a cosmetic procedure saying that it's not safe because of the transmission risk to staff. And there's a really fine distinction here between direct discrimination and discrimination arising from disability. They're not strictly refusing your client because they are living with HIV, but because of the supposed transmission risk to staff. However, since the clinic should be using standard precautions, universal precautions, which prevent the transmission of bloodborne viruses with all patients, their behaviour towards your client cannot be justified and is therefore unlawful. However, there might be instances where differential treatment of a person living with HIV because of something connected to their HIV is justifiable. So for example, when a doctor advises a mother living with HIV to formula feed her baby despite advising mothers generally to breastfeed, this can be justified because there is evidence that indicates that there's still a low risk of HIV transmission through breastfeeding, even when the mother has an undetectable viral load. And yeah, it's important just to note that not all poor experiences of service are necessarily discriminatory. For example, a long waiting time for surgery is not in itself discrimination, but if your client is repeatedly put to the end of daily operating lists due to additional cleaning requirements related to their HIV status, that is discrimination. So I'm going to move on to the next piece of legislation, which you've probably all already heard of, which is the EU's General Data Protection Regulation. But the Data Protection Act of 2018 is the piece of UK legislation which brings the requirements of GDPR into UK law with some additional requirements. It's a huge piece of legislation which governs how organisations process your data. And it aims to ensure that people can trust organisations to use their data fairly and responsibly. But because every organisation is different, data protection law doesn't set many absolute rules, and it takes a risk-based approach instead, based on some key principles which are outlined on this slide. But this flexibility can make it harder to understand how it applies to people living with HIV specifically. But the more we raise issues and discuss it with the regulator, the more we will be able to understand how this law is useful to people living with HIV. So one of the most relevant principles to people living with HIV is the principle of data minimization. And this states that data collected must be adequate, relevant, and limited to what is necessary. And this means that the organization collecting the data should collect enough data to fulfill their stated purpose for collecting it. The data they are collecting has to have a rational link to that purpose, and they must not collect more data than they need for fulfilling that purpose. Collecting information about HIV status is completely unnecessary in the context of tattooing, piercing, cosmetic or routine beauty treatments. So yeah, it's a breach of the Data Protection Act to ask people about their HIV status as a requirement of providing these services. But because the Data Protection Act is principle-based, the lawfulness of an action can vary depending on the situation. And it doesn't mean that it's always illegal for someone to ask about HIV status. Another relevant principle is that of integrity and confidentiality, which states that appropriate security measures must be in place to protect any personal data held. And this is often relevant where someone has had their HIV status shared with others without their consent or stored in a way that breaches their confidentiality. And finally, the Human Rights Act of 1998 is the piece of legislation which brings the European Convention of Human Rights into UK law. And the Human Rights Act describes these rights as a series of articles. Particularly relevant articles to people living with HIV are Article 2, which is the right to life. For example, an application of Article 2 could be if a prisoner living with HIV has their medication withheld and then dies in prison. Article 2 would be very relevant for their family when trying to get justice. Article 3 is the right not to be subjected to torture or inhuman treatment. And this will be relevant in a case when a person living with HIV is not provided with appropriate care in a care home, for example, because of misplaced fears around transmission or HIV-related stigma. Article 8 is the right to private and family life. And this will be relevant in a case where the police are demanding access to the HIV clinical records of a victim of sexual assault, despite this having no relevance to the crime. And all of these examples I've given around the Human Rights Act are based on real cases on which we've given advice, which just shows how important the Human Rights Act can be for people living with HIV. And then finally, Article 14 is the right to be free from discrimination. And this can only be used together with other articles in the Act. So the Human Rights Act is a really crucial piece of legislation because it's about holding public authorities to account. And it allows individuals to take action against public authorities who have interfered with their rights, such as local authorities, the police, healthcare services, and importantly, the government. And that's probably plays into the reasoning behind why this government have sought to kind of reform it. So now we can move on to taking action. We haven't got a huge amount of time before Adam comes, but we can definitely cover quite a lot. Let me just find the right places in my notes, excuse me. So, yeah, in any form of discrimination, including in healthcare, tattooing, piercing and cosmetics, it's always helpful to have detailed records of any correspondence, including phone calls. So always try and encourage your clients to record as much as possible who they're speaking to, the date and time that these phone calls happened, because it does make it a lot easier to challenge discrimination. And I mean, it's just good practice in general, but if they start to suspect that they're being treated differently and worse and it could amount to discrimination, that's a really good kind of point to be like, right, I'm gonna start retaining as much evidence as possible. But specifically in piercing, tattooing and cosmetics, once you've identified that discrimination has taken place, the first step is usually to write a letter of complaint to the organisation or person who discriminated against your client. We're working to develop template letters which will be downloadable from our website to aid this, where you could just kind of like populate a template with the kind of specifics of the situation. But it's good to include to begin with a factual description of events, including dates and names, job descriptions if known, why this amounts to unlawful behaviour and which laws apply, the impact this has had on your client, and that can be really far ranging. It can be kind of like the kind of emotional, physical, financial impact that this has had, just to kind of, it just shows the human impact that this discriminatory behaviour has had on them. The next steps, the outcome your client would like to see, and obviously always consult your client before in the whole process of writing these letters as well. So if they've had discriminatory behaviour at a piercing parlour, you might not want to say, they might not want to go back, but they might want them to reform their consent form so that they're not being asked, no other person is asked about their HIV status, for example. But having said that, some people might say, I actually just want to go back to the same place and have my piercing and be treated fairly. And also important to include a deadline for response. So 2 weeks is usually reasonable from the date that you sent your letter, just to get like to get a response. But that means that it tends to help letters not go unanswered for a long time. So yeah, if you don't receive a response and your complaint relates to piercings and tattooing, then there are further steps to take. And in England, Wales and Scotland, providers of tattooing and piercing must have a license, which is issued by the council. And this is called like a piercing, tattooing and electrolysis license, I believe. And you can escalate the complaint by writing to the council and informing them that a premises that is in breach of the conditions of their license, and you can ask the council to intervene. The letter can be very similar to the letter to the company or organisation that we just spoke about in terms of its structure and the contents, but just tweaked to stress that it's specifically in breach of the license conditions. Which department you write to can depend on the council's structure. It's usually the environmental health team which issues these licenses, but I have come across different teams and different councils. And the timelines for response are slightly longer than usual. So I would normally put a time frame of 3 to 4 weeks in this letter, just because it just takes a while to get through the various layers of people to find, sometimes to get a response. It just takes a bit longer than if it's a private business owner or individual or organisation. But if your initial letter was relating to cosmetics and that the response to the letter was unsatisfactory, or you haven't received a reply, then taking further action can be a bit more challenging in cosmetics than it is in piercing and tattooing, because it's not a very well regulated industry yet. It's possible to carry out cosmetic procedures with very minimal training and qualifications. So as a place to start, it's good to check if a provider is registered with any regulatory bodies or associations, because you can write to them about their members. And some of these, so Save Face, you can write to, even if they're not a member, just to highlight the issue to them and ask them to intervene. So it's always good, though, to encourage your clients to thoroughly check the person is qualified and has the right training, skills and insurance to carry out a procedure before they go ahead and book or try and have it. And this is something we can ask Adam later if relevant. But we receive quite a few queries from people being refused treatment or refused, a service, or charged extra for a service specifically for cosmetic procedures abroad, mostly in Turkey. And it is quite interesting to consider the geographical application of the Equality Act, because it doesn't apply abroad, even if the company is registered in the UK and operating abroad. There's very little protection that's afforded if that's not in the UK, which is important to consider. So moving on to healthcare, when you have identified that there has been a form of discrimination, the first step is usually to raise the issue with the patient advice liaison service, who will support your client to resolve the issue informally. And it's possible to speak to a PALS representative in person, but it's often easier to write them, especially given that many face-to-face services are still not up and running yet. And if you don't feel satisfied by the response from this service, the next step is to write to the chief executive of the NHS Trust, or if it relates to primary care, you can write to NHS England or your local clinical commissioning group, or CCG, if it relates to secondary care. And this would follow a very similar letter template, so a factual description of events, why it amounts to unlawful behaviour, which legislation applies, and the impact this has had on your client, next steps, and the deadline for response. However, if that doesn't yield the results that you want and you need to take further action, then you can contact the Ombudsman. And in order for the Ombudsman to take on your case, you have to have completed the complaint process at the NHS organisation in question. So they won't consider your case until you've done that, until you've completed it. So this normally means you have to have complained and received a reply. And it's important to note that the time limit for contacting or bringing a complaint to the Ombudsman is 12 months from the date of the instance, so 1 year. There will be a session in a couple of weeks' time, specifically around breaches of confidentiality, which will include a more detailed look at data breaches in healthcare settings. But again, we recommend that your client, well, you first have to make a complaint to the organisation or person who mishandled their data, who breached their data. So if this response is not satisfactory within 1 month, then you can report them to the Information Commissioner's Office, the ICO. And you can always make sure that when you're doing this, you can always encourage your client to include the details of your support service or National AIDS Trust or both, so that the ICO can get in touch if they do need more information about HIV as part of their investigation. And the time limit for a complaint to the ICO is 6 months from the data breach, but they will consider longer time periods if there's been a good reason for the delay in making the complaint. So yeah, that's a quick summary of how to take action using the law to challenge discrimination without actually taking legal action. And it's important to bear in mind the limits to taking legal action. And you can discuss the pros and cons of taking action with your client while you're supporting them with their complaint. The Positive Voices survey found that of those who needed legal advice, and this is in all settings and all scenarios, not just specifically in healthcare, cosmetics, tattooing and piercing, but it found that 2/3 of respondents couldn't or didn't try and access it when they needed legal advice. And this, I think, reflects the fact that sometimes taking legal action can be more trouble than it's worth. And sometimes it's not appropriate because the incident may have taken place outside of the strict time limits for taking legal action, or your client may not want the stress and emotional burden associated with the legal process. And taking court action can also be really expensive, and it's important to keep in mind that if your client loses the case in court, they may have to pay the other side's legal costs, which could be really high. Legal aid is available for discrimination cases, but it has very strict eligibility criteria, and very limited pro bono support is available, which means it's much harder for lawyers to undertake pro bono work since the legal aid cuts. And even if your client decides not to take action, it's definitely still worth raising the issue with us. If we have widespread evidence of discrimination in a particular area, we can use this in our advocacy work when lobbying policymakers and regulators. And another strength of HIV support services in this kind of advocacy work is that you can take a more holistic approach. So even if you don't manage to resolve the issue of discrimination in the way that your client would have preferred or would have liked, you can support them to deal with it by offering emotional support and linking them in with therapy and peer support, for example. So equality law is largely enforced through the courts, and the court in which a claim should be lodged depends on where the discrimination took place and who is discriminating. So for areas of discrimination which are not employment, which includes healthcare, piercings, tattooing, cosmetics, claims should be made in the county court in England and Wales and in the sheriff court in Scotland. But one thing that's important to bear in mind is a time limit for taking legal action. So for non-employment discrimination cases, you must start legal proceedings within 6 months less 1 day from the date of discrimination. And if there were multiple connected instances of discrimination, the time limit will be counted from the most recent date of discrimination. And this is why it's really important to quickly establish with your client when the discrimination took place and seek advice as soon as possible, even if the situation is resolved before going to court, because there's actually not a lot of time to address these concerns. And there is a regulator. So the Equality and Human Rights Commission is Great Britain's national equality body and has unique powers to challenge discrimination, promote equality of opportunity, and to protect human rights. However, it does mostly focus on systemic issues as opposed to individual cases. And there are some exceptions to this, but they are relevant to discrimination within employment. So they'll be covered in our session next week. Yeah, the EHRC can be useful in contacting to kind of highlight more systemic issues that are experienced by people living with HIV. And I've sort of already mentioned this briefly, but the Data Protection Act is regulated by the Information Commissioner's Office. And unlike the EHRC, it's possible for individuals to directly ask the ICO to investigate their complaints for free. But your client must have made a complaint to the organisation handling their data first. And this is why we always recommend writing that initial letter of complaint first to try and resolve it in that way. If they're not satisfied with the response or they haven't heard back within a month, they can then report the organisation to the ICO. And it will usually only investigate a complaint relating to a breach within the last 6 months. But they are flexible. Like I said, if there's a good reason for delay in reporting a complaint, but just important to bear in mind the 6-month time limit. And the ICO can investigate a complaint and give their opinion on whether data protection law has been breached, and they can issue fines to organisations, but they cannot award compensation. So individuals are entitled to claim compensation if their data rights have been breached, but this often needs to be decided in court, and complainants have 6 years less 1 day from the data breach to make a court claim. So the Equality and Human Rights Commission also regulates the Human Rights Act, although again, it's mostly focused on systemic rather than individual matters. Generally, individual matters relating to human rights are enforced in the courts. And if you do want to bring a case under the Human Rights Act, you need to decide which court you should make your application to. And this will depend on what your complaint is about and the remedy that you want the court to order. So when you want to take court action about a decision by a public authority, you will usually make an application for judicial review unless there's another better way of challenging the decision, for example, an appeals process. And in England and Wales, an application for judicial review is made to the High Court, and in Scotland, it's made to the Court of Session. And time limits for enforcing human rights in court are 1 year less 1 day from the human rights breach, although judicial reviews must be made within 3 months of the decision which is being challenged, which can make it very difficult to try and resolve the matter informally beforehand, to complete complaints processes. So 3 months is a very tight deadline if you do want to take court action on this issues. And since there are different processes to follow, depending on the context and type of discrimination, it's generally best to seek advice first if you're unsure or the situation is complex. And it's important that you check with your client as soon as possible if they qualify for legal aid, or if they can access any legal aid support via trade union membership or home contents insurance, even if they're unsure about taking legal action, just to kind of get ahead in that process as much as possible. And on this slide, I provided a link to the government's legal aid eligibility checker. So yeah, that was a brief whistle-stop tour of how to challenge, once we've identified the discrimination, how to challenge it. And I hope I've also shown the benefits of not, or how it's so possible to apply the law without taking formal legal action, and use it to advocate better for our clients.